All right, so let's get into these basic estate planning documents. What happens if you don't have them? So what are they, and what happens if you don't have these fundamental estate planning tools? First of all, we're going to focus on living documents. Those are your durable powers of attorney. So a durable power of attorney is an estate planning document that you would sign where you designate someone to make decisions for you in case you can't. If you lose capacity, if you can't manage your own decisions when it comes to finances or for healthcare, somebody needs to be able to make those decisions. So it's through a durable power of attorney document that you grant authority to somebody else to make decisions for you if you're not able to do so. Under the durable power of attorney statute, which in Washington is RCW 11.125, it's very important that specific grants of authority be included depending on what you want that person to be able to do. That person who you designate under your power of attorney is called your attorney in fact, your agent, your proxy, your POA. All of those mean the same thing. That's the person that you've given authority to manage your affairs if you can't. The document is called durable for a reason. Durable means that this grant of authority to somebody else to make decisions for you continues even if you lose capacity, which is exactly what the document is intended to do. For most people, if they're capable of managing their own affairs, they're going to do that. They don't want somebody else to step in and manage their affairs. So the power of the durable power of attorney is that it is durable. It continues in effect even when you are not able to make your decisions, which is exactly what we want this document to do. Under the durable power of attorney, you have the ability to say, hey, I want my husband, my daughter, my son, and whomever to be able to manage finances if I'm not able to do so. I want my husband, my daughter, my son, whomever I want to designate to make medical decisions for me, to talk to the doctors if I'm not able to do so. If I'm able to do so, I'm going to make those decisions myself. But the power of attorney protects you in case you lose the ability to make such decisions. Under the durable power of attorney statute, you want to include what authority it's important for those persons to have. Now, backing up a little bit, you heard me say my husband, my daughter, my son. They're not all going to be making decisions for me. I'm going to do it in a cascading order. First position is my husband, then my daughter, then my son. Why do I name these successor agents? The reason that I do that is perhaps my husband and I are in that same auto accident, so he can't make decisions for me. So then my daughter needs to step in and make decisions for both myself and for my husband. You have to have cascading order of successor decision makers so that that position is never empty. There's a reason for that. I'll get back to that. What kind of authority should you include in this basic fundamental document? I recommend that you include what authority so that they can actually manage your affairs. So as an estate planning and elder law firm, we often help clients protect assets during their lifetime and also after their death, especially against long-term care costs, the number one threat to financial security. So our durable powers of attorney are going to be more comprehensive. They're going to contain more grants of authority than a simple, basic, durable power of attorney. Again, what we're talking about today is estate planning basics. So I don't want to spend a whole lot of time talking about what an elder law attorney would include in a durable power of attorney. Those are the details I think that often bog people down when they come to what document should I sign? What estate plan do I need? Is that they get bogged down in the details. So what I'm going to say is everybody needs a durable power of attorney for finances and for healthcare decisions. It protects the person in case they lose capacity, they lose the ability to manage their own financial affairs in their own medical affairs. Designate successor agents and make sure that the person that you're designating, the people you're designating to make decisions for you, are people that know you, if you have that ability, people who you trust, and people who will be your voice in case you can't speak for yourself. Make sure your document is durable. A non-durable power of attorney isn't going to do you any good if you lose capacity. For people who don't have family members or friends that they can name, there are professional fiduciaries who know what they're doing, who will fill that role, who, in case you lose capacity, will be there to manage your own affairs. Yes, those people will require a fee, and that often puts people off. It's like, I don't want to pay anybody for that role. Well, if you don't have any family member or friend or anybody that you could otherwise designate to be your decision maker, you really don't have a choice. You need to name a professional.